The U.S. Supreme Court hears arguments Wednesday in a high profile case involving school choice. And as the issue hits the national spotlight, now is a good time for an update on a legal challenge to school choice right here in North Carolina. Joining us to offer insight is Ari Bargil of the Institute for Justice. He is lead attorney in the North Carolina case. Ari, thanks for joining us.
Thank you for having me.
Before we get into the details of what's happening with school choice and the legal challenge in North Carolina, remind us this case, Carson v. Macon, that's heading before the Supreme Court. What's the bottom line that the court's going to be deciding here?
The central question in Carson is whether the government, when it creates a school choice program, can prohibit participation in that program by a religious institution because the religious institution teaches religious things as part of its curriculum.
Okay, so that is in front of the Supreme Court. It brings school choice back to the forefront to people's attention. It's a good time to remind people right here in North Carolina, there is an ongoing legal challenge involving the Opportunity Scholarship School Voucher Program. You are lead attorney for the Institute for Justice on this. Tell us what's at issue here in this state.
The issue is somewhat similar. The plaintiffs in the North Carolina case have brought a legal challenge attempting to bring down the entire educational choice apparatus in North Carolina on the grounds that the participation in the program by religiously affiliated schools creates constitutional problems vis-a-vis the individual beliefs of other people who don't even participate in the program.
This Opportunity Scholarship Program has gone through North Carolina courts once. In fact, our state Supreme Court ruled 4-3 several years ago that it was on its face constitutional. I understand that this time around, though, the challenge is how the program has operated, what the legal folks like to call an as-applied challenge.
Well, that's part of what we're arguing, is that this is not, in fact, an as-applied challenge, which is when one person comes into court and says, as this law applies to me, it operates unconstitutionally. And the plaintiffs have tried to frame their case as being an as-applied challenge, but we know that it's not because of the way that they've asked for relief from the court. And, in a nutshell, what they've asked for is for the wholesale cessation of the Opportunity Scholarship Program for everybody in North Carolina, all participants and all potential participants. And that's what actually makes it a facial challenge rather than as applied one. So these are sort of the games that lawyers play in order to try to get the outcomes that they want. But ultimately, at the end of the day, when what you're trying to do is to bring down an entire system within the state, it's near impossible to style that as a challenge that's laser focused on just one or two individual people.
We interviewed one of the parents, actually in this case a grandparent, who was participating in this case shortly after the suit was filed, Janet Nunn. She had a very emotional story about her granddaughter and how Opportunity Scholarships had helped her. That was back in 2020, well over a year ago. What's been happening on the case?
Well, it's been sort of in a procedural morass. I don't want to bore all of your listeners, but one of the things that we've been fighting about the most has been this as-applied/facial distinction that you brought up a moment ago. So we're going to be going to the North Carolina Court of Appeals to resolve precisely what is the nature of the claims brought by the plaintiffs here. And once we get a court to actually speak to that issue, it's going to answer a lot of questions about whether this case is going to be heard by one judge or three judges sitting as a panel.
And for folks who haven't followed the legal proceedings very closely in North Carolina, if there is a constitutional challenge to the very nature of the law, it has to go in front of a three-judge panel. So that is the argument that you all are making, is that this should go before a three-judge panel?
That's right. And while I don't want to get into the legal weeds, I think it's important to take a step back and understand why the North Carolina legislature created this apparatus in the first place. And it's to make sure that these really important decisions that affect people throughout the state of North Carolina are not being made by individual trial judges in certain localities, not to discriminate against any of those localities, but the legislature acknowledged, the General Assembly acknowledged that it was important for really important issues that affects all of North Carolinians for those issues to be decided by more than one judge, but rather three judges in Wake County. And so that's what we're trying to get a court to acknowledge, that this is a really important case, one that implicates legal questions and the interests of people throughout the state, and not just in one county or another. And so because of those things, we know that this is a facial challenge and it needs to be heard by a three-judge panel. And that's what we've taken up to the North Carolina Court of Appeals.
You mentioned that this is an important case. As important as it is, it sounds like it's been dragging on for quite a while. It's been well over a year since we first heard about this. There hasn't really been any major trial or extensive hearing about the case, has there? That's mainly been sort of back and forth, probably filing paperwork, maybe a short hearing on technical matters.
Yeah, the practice of law is not what you see on TV, and so we've been sort of mired in a lot of that exchange of paperwork over the last year or so. But it's not super atypical for cases to move this way, especially when you're dealing with some of the really complicated, really important issues that this case involves. And so we're continuing to move it along. And, I expect that, before it's all said and done, it may be the North Carolina Supreme Court who ultimately resolves this case. And that probably won't happen for a little while as well.
Well, we've spent a lot of time really on kind of the weeds and the procedural matters, but let's get back to the heart of the case. Why are the clients that you're working with involved in this, and why is IJ working to help protect this opportunity scholarship program?
The parents we represent are involved for a very simple reason. They love their children or their grandchildren, and they want them to receive the best education possible. And by best education, we mean the education that's best suited to their individual children's needs, whether it's a public school education, a private school education, or a private school education being provided by a school that has religious affiliation. And that is what the Institute for Justice fights for, is the right of parents to be able to have control over the educational futures of their children. And that's why we've sort of joined with these parents to make sure that the Opportunity Scholarship Program is available to them, and that they're not funneled back into the very public school system that wasn't working for them, that led them to seek out other options in the first place.
If the groups challenging this program succeed and opportunity scholarships are struck down, tell us what kind of harm that's going to create for the clients that you're working with and the thousands of other families that use these scholarships.
In sum, it would be catastrophic. There are 12,000 students who take advantage of this program, and they would all be funneled back into the public school system. I think there might be a handful of them whose parents would scratch and claw to be able to make ends meet so that they could continue to send their kids to the schools that have been working best for them. But for the most part, all of these families will be forced back into a system which they opted to leave when given the opportunity. And that's deeply problematic, not just because it doesn't allow parents to exercise choice, but because it highlights some of the inequities in our system. After all, parents who are of means and wealthy families already have school choice. They can afford to send their kid or their kids to whichever school they want. But that opportunity isn't available for everyone in our society. And the purpose of this program is to allow low-income folks to be able to exercise the same degree of control over the educational futures of their children that people who are of means already have.
A majority of our General Assembly supports this program. And in fact, in the latest budget that was just recently passed, it expands. So if opportunity scholarships are struck down, there's an even larger pool of people who would be affected than just the thousands who are already in this program. I imagine that that's going to end up being a factor as this case moves forward too. The fact that it's not just the parents and families who are already involved, which numbers are in the thousands, but it's going to be an even larger group.
Yeah, and I think that tells part of the story. These programs, if you ask the people who use them, are immensely popular. And as you mentioned, the people of North Carolina, through their representatives, wanted to have this put in place and made available to parents throughout the state. There are a handful of people who are trying to undo it, but at the end of the day, as these programs grow and expand, what we're learning is that not only are they immensely popular, but they also work as well. And unfortunately, they've become politically controversial. But the question of whether the Opportunity Scholarship Program in North Carolina or other similar programs in other states ultimately allow parents to exercise a greater degree of choice and to provide better futures for their children, I think that question is largely resolved. And all you need to do to know that is to ask the parents. They always have the option of sending their children back to their assigned public school if they wish, but they frequently decide not to do that. They overwhelmingly decide not to do that, and the reason is not because the public schools are worse or better, but because for whatever reason, certain parents want different types of educational options for their children, and this provides those options. And without it, all of those parents will be forced to send their kids back to the very system that they believed wasn't working for their child.
As we conclude, you've mentioned this earlier, but let's remind folks again who have been following this and said, oh, yeah, I haven't heard much about this case in a while. Where do things stand right now, and what will be sort of the next decision point as this case moves forward?
So the North Carolina Court of Appeals is going to decide in the next couple of months whether this is an as-applied challenge or a facial challenge. And basically what that means is, are they going to accept the plaintiff's theory that because a handful of plaintiffs have identified specific things that they don't like about the way the program applies, or are they going to acknowledge that if the plaintiffs win in this case, it'll mean the complete dismantlement of the program for everybody in North Carolina? I think that spells out that this is a facial challenge by virtue of the fact that this is an attempt to completely bring the whole system down. But ultimately, that'll be a question for the Court of Appeals. And once they decide that, we'll know who our judge or judges will be, and then the case will be heard on its merits and ruled upon in due course. And so we're looking forward to kind of getting that procedural hurdle out of the way. That way, we can get a decision on this. Our parents can be comfortable without worrying that their children's educational futures are hanging in the balance. And hopefully, to get back to how we started this conversation, by the time this is all said and done, we might get additional guidance from the United States Supreme Court on some of the claims that the plaintiffs have raised in this case.
And if people want to learn more about the specifics of the North Carolina case, I know they can go to the website of ij.org. Anything special they need to search for? School Choice North Carolina, or a particular name?
I mean, if you're going through Google, Institute for Justice North Carolina School Choice will take you to the right place. But if you're on our website, we've got a school choice tab, and you can explore all of our school choice work. And in very short order, you'll probably be able to find the North Carolina School Choice case page.
Ari Bargil is an attorney with the Institute for Justice, the lead attorney in this case in North Carolina. Thanks so much for joining us.
Thank you very much for having me, Mitch.